Did the police really tamper with evidence in the Karen Reed trial? Well, that's what the defense is saying in their latest attempts to dismiss the case. Reed is about to be tried again for killing her boyfriend, Boston police officer John O'Keefe, by intentionally hitting him with her SUV. The theory advanced by the defense is that she was framed by corrupt cops. This particular motion focuses on surveillance video that they insist was tampered with. Reed's SUV was towed to the Canton Police sallyport, which is a garage, for inspection on January 29, 2022 at 5:30 p.m. This was part of their investigation to view the damage to her vehicle. Now, the defense claims that the taillight of her SUV was only cracked at the time. They claimed she cracked it when she accidentally hit another car as she was backing out of the garage. The defense believes that the taillight was in fact shattered in the Canton Police sallyport by shady police attempting to frame Karen Reed. Now, the defense argues that it really was corrupt state police trooper Michael Proctor who manipulated the video. Now, this is their argument in a nutshell. I always try to be very neutral in my approach, so don't judge yet. Special Assistant District Attorney Hank Brennan will present an opposition argument, which I'll analyze in my next video. After that, let me know what you think. The following is Defense Attorney Alan Jackson discussing that corrupt sallyport surveillance video. Please note I've increased the video speed to save time.
We received exterior footage that would ordinarily show the condition of the passenger taillight, which all happens to be corrupted, like every other video of the rear passenger side of that SUV. This is stunning. Michael Proctor and other investigators intentionally secured these videos. They withheld the evidence from us, and they withheld the evidence from the prosecution team. Let's take them at their word. Even after being explicitly instructed to turn over that evidence, that is bad faith. There's a pattern engaged in by the Massachusetts State Police, by the Canton Police Department, over and over and over again. And now we know, through this new revelation, that it was intentional. Probably because they didn't help the prosecution. They showed Higgins engaged in conduct that is, at the very least, highly suspicious and clearly exculpatory because it impeaches his other testimony. It shows him on the phone. And he testified that he didn't make calls in the middle of the night. There's no question that with this example, that is an intentional withholding of evidence. That is the legal definition of bad faith, and it's unconscionable. It's not like the Canton Police Department and the Massachusetts State Police were sort of blissfully incompetent or blissfully ignorant and unaware of the existence of these exculpatory videos. It's quite the opposite. Multiple officers, Proctor, Rafferty, Buchnick, O'Rourke, DJ and Petro, these individuals, we believe, O'Rourke may not have known, but we know that the others did, and have now basically admitted it or been caught trying to hide it. They were all variously actively engaged with these videos. They were searched for, they were discussed, they downloaded them, they saved them, they copied them, they labeled them, they transported them, they reviewed them, and they strategized about them. These videos were top of mind for all of these folks. We know there were hours and hours and hours of footage that was so large it had to be broken down into 6-hour blocks. All of that was pulled. And none of this footage was disclosed to the defense before April of 2024. And most of the files that have been turned over so far have been turned over after the trial was over. We had no idea this footage existed, and to this day, it continues to be, the bulk of it continues to be withheld from the defense. This case still has to be dismissed under the second scenario and the second prong. Ms. Reed has suffered actual prejudice by the Commonwealth's violations. We could not cross-examine these witnesses the way they should have been cross-examined at the first trial. The repeated and flagrant discovery violations were not an accident. I think we've established that at this point. They weren't a mistake. There were too many people looking at them, strategizing about them, to then say, I didn't realize their import. They were designed specifically, the fact that we weren't provided the evidence was designed specifically to obtain a strategic advantage over the defense and to get a conviction at all costs rather than to pursue the truth. There are obviously additional Brady violations and prejudices that Ms. Reed has suffered. This was intentional. And the Commonwealth then compounded those violations by Michael Proctor lying on the stand about his knowledge of the video footage and his turning it over to the defense. It was literally a fraud on the jury. And now, well after trial, the Commonwealth has been forced to admit that even more exculpatory evidence or surveillance evidence from January 2022 is in their possession, and it was also entirely withheld from the defense throughout this litigation and throughout their first trial. In addition to the presumptive prejudice, Your Honor, there has been actual prejudice. This was, some would say, a close case when it ended. The court recalls that. The jury was hung on some charge or charges, and the evidence suggests that they voted in her favor on others. The court needs to ask itself, what would the jury have done had they had all the evidence to which they were entitled, to which we were entitled? But they didn't. Every one of these videos was in some way compromised, even the videos that we did have. And the compromise always conveniently obscured the truth and obscured Ms. Reed's rights. This is an exculpatory fact that we should have been able to explore during the past 3 years, and certainly we should have been able to explore it at trial, but we did not have the videos. The Commonwealth did, though. And it's the cumulative effect of all these gross and repeated violations that undermines the Commonwealth's argument that this is just about a broken camera. It couldn't be further from the truth. We're to believe that all these cameras just spontaneously became defective at the exact same time. Like I said before, it defies logic. The only remedy that can prevent this kind of repetition, this kind of misconduct, is dismissal. That's the only remedy available.
Wow. Do you really think this case should be dismissed? Well, let's wait and see what the Commonwealth has to say. In the meantime, do me a little favor and subscribe. And once again, thank you for listening.